Assalamualaikum warahmatullahi wabarakatuh. My name is Melanda Septyana Maharani, and now I would like to explain about the law enforcement against forest fires in Indonesia from an environmental law perspective. The forests are the natural resources that have an important role in supporting national development. The environmental pollution and damage in the case of forest fires in Indonesia is a serious problem. The forest management and prevention of forest fires have not been maximized, as well as the law enforcement for the perpetrators, whether on purpose or due to their negligence in causing forest fires. In the 1945 Constitution, Article 33, Paragraph 3 states that the earth, water, and natural resources contained therein are controlled by the state and used for the great prosperity of the people. And in the Article 28 letter H, paragraph 1 state that as people live in prosperity physically and mentally, residing and getting a good and healthy living environment, as well as receiving healthy service. In this article, it is stated that every citizen has the right to a good and healthy environment. Therefore, the environmental law enforcement is an instrument to create a good and healthy environment. In Law Number 32 of 2019 concerning the environmental protection and management regulates law enforcement in the environmental sector, which is classified into three categories, namely the enforcement of environmental law in relation to administrative, the enforcement of environmental law in relation of civil law, and the environmental law enforcement in the relation of criminal law. The three existing environmental law enforcement apparently have not been able to resolve exciting environmental case, so there is still a lot of pollution and environmental damage in Indonesia. There is still a lot of environmental damage that has occurred is an indication of the failure of environmental law enforcement. One of the problems of environmental pollution is air pollution from forest fire. Forest fire case occurs because of individual or group interest to carry out development in forestry areas that ignore the preservation of the existing environment. The problems of living forests result in air pollution, which is very difficult to handle. The existing of forests has an urgency in life. Forests protect water and resource and provide oxygen. In Law Number 41 of 1999 state that the implementation of forestry is intended for the great prosperity of the people in a just and sustainable manner. The law on forestry has regulated the prohibition of burning forests and land, as stated in Article 15, Paragraph 3, letter D, which states that everyone is prohibition from burning forests, and the Article 69, Paragraph 1, letter A and H of the Law on Protection and Management of the Environmental State that every person is prohibited from the committing acts and cause environmental pollution and limits the clearing land by burning. The environmental law enforcement against forest fires serve as a means of preventing and reducing the occurrence of fires, which occurs almost every year. The environmental law enforcement includes several processes, and each process refers to legal provision in both formal and material crimes. The steps in environmental law enforcement include preventive action, and repressive action. The preventive action is an anticipatory action that is to detect early the various factors that allow environmental damage or pollution, and the preventive action is a service of concern action aimed at preventing environmental damage or pollution, and the last repressive action are action taken by the legal officer through a criminal legal process because the act committed have damaged or polluted the environment. The administrative environmental law enforcement. Administrative environmental law enforcement can be preventive in nature and aim to enforce environmental law and regulation. The administrative environmental law enforcement is carried out on activities related to permit, requirement, environmental management plans, and so on. In administrative law enforcement, the sanction given includes provision of permit, forest burning activities, and administrative sanction for those proven to have committed violation in the form of license supervision, the revocation of business right and environmental permit, as well as sanction on land tenure by the government. The application of administrative sanction is one of the most effective ways to enforce law in the forestry and plantation sector because the application of sanction does not go through a long and convoluted process as using the usual procedure. The authority to apply administrative sanction is basically discretionary power. Therefore, the agency authority to impose administrative sanction. The authority to apply sanction with various considered, for example, economic reason, inadequate instrument of coercion, unable for force, and official doubts about an offense, and others. Criminal environmental law enforcement. Law enforcement in the criminal environment is a repressive action. This action is carried out in the event of an act that violates the rules, while the instrument used the application of criminal sanction. The criminal law enforcement against forest fires cases have been carried out through various stages, including the formulation stage, the application stage, and the executing stage. The stage of the formulation of criminal law against forest burn have been included in several actions of statutory regulation which can be used as legal basis to ensnare forest burning by enforcing criminal law. The law regulates the crime of forest burning include Plantation Law number 39 of 2014, Forest Law Article 78, and Law number 32 of 2009 concerning the environmental protection and management. Of the several law and regulation that contains criminal sanction relating the forest fires, law enforcement must still observe the principle of legality as the basis of implementing criminal sanction. This legality principle contains three definitions. There is not act which is prohibited or punishable by punishment if that has not been stated in a statutory regulation. In determining the existence of a criminal act, analogy should not be used. The rules of criminal law are not retroactive. And that's all from me. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.